that will be a major issue when we come into Metaverse and non-fungible tokens. Different countries and different courts have adopted an entirely different approach. Some countries are saying hands-off approach with regard to intermediary liability, while countries like India are trying to adopt greater accountability of the intermediary. So there is going to be a conflict, and one will have to deal with this issue at some level. How it is to be dealt with, there may be various views how it is to be dealt with to avoid conflict of laws. The same issue may arise simultaneously in different courts all over the world. Would it be possible to have a joint hearing, although the courts will have to give independent rulings, but can they hear the same issue where one of the parties is common jointly and then decide it separately, but they must have the benefit of the view of the other country as well available to them, and then take a reasoned decision. See, because we may be deciding in silos, without considering a facet or an argument which is advanced by another party in another jurisdiction. How do you deal with it? So there are a lot of complications, and the legislature will have to step in to resolve this issue at some particular point, unless until globally there is a consensus on some basic principles which have to be adopted, or the approach that has to be adopted with regard to these issues.
Yes, I would agree. And there are also these new kind of questions, how you deal with the interoperability in between the NFTs, which are in different metaverse. Is it something that you respect as ownership right on one of the metaverse or on all of them? Do you have a transversal ownership right? Then how long does it exist? For example, if one of these words finally stops to exist for, I don't know, economic reasons, how you get back your money, and if it's a trademark which is registered only as a valuable asset on the metaverse, what does it mean? Is it a new kind of end of life of a trademark? So I think the questions are quite interesting.
Yeah, just what you just raised, Andre. So is, let's say, a different platform considered a different jurisdiction? Can you have a right in one and not the same right in the, does that transfer to, where does interoperability stop? And then, as Manmohan was saying, if you have one court deciding that you may not use a certain sign or symbol in its jurisdiction in the metaverse, and the user continues and simply claims, well, I'm not using it in India. I am located in country X, and the metaverse is, for me, consists of Europe. So I am not using it in India. The fact that people can access it from India is nothing I can control. So all of these questions kind of lead back to the discussion we had previously of the lack in harmonization, which I think is going to become so much more critical in this kind of borderless and less, let's say, territoriality less space.
This is very interesting what you are saying, because I'm just thinking now aloud of a situation. Let's imagine a global metaverse which is accessible from India, from US, from Brazil, from Europe, and a person would on this metaverse only buy or prepare a product which is trademark, which on the metaverse will always stay limited to the European territory, where it would not be an infringement of anything, but really would be an infringement of a trademark in the US, in India, in Brazil. What does it mean? Can he have this defense of saying, look at the metaverse, I'm not going out of the territory? It would be an interesting question.
But consumers in Peru will be able to see the advertisements and will be able to buy the products or things like that. The fact that, so it's really complicated.